Welcome to This Explainer. So, today we're diving into what I think is a truly fascinating legal mystery. Who can you actually hold accountable under the Constitution? When we think of the state, our minds instantly go to ministries or the parliament. But what on earth happens when the government sets up these independent societies or outsources its duties to organizations that, well, look completely private on paper? Under Article 12, pinning down the exact definition of the state is literally the absolute starting point for enforcing your fundamental rights. So let's look at how the Supreme Court completely shook this out and redefined it in 2026.
Think about it. If an organization is footing its own bills, is it still the government? For the longest time, the legal world was just totally fixated on the money. This assumption was kind of creeping in that if an entity didn't rely on the government's purse, meaning no direct budgetary support, then it absolutely had to be a private entity. But this is the exact million-dollar question the Supreme Court of India had to definitively answer in 2026. And I'll tell you, their decision radically changes how we view government outsourcing and overall accountability. Moving right into Section 1, what is the state? Understanding Article 12 limits. Let's head into Section 2, the Air Force case. Ravi Kokar versus Union of India. Okay, so to really grasp this ruling, we've got to look at the facts. We're dealing with the Air Force Group Insurance Society, or AFGIS for short. Now, this is a welfare and insurance society set up specifically for Indian Air Force personnel, and it's registered under the Societies Registration Act. Well, back in 2017, the board of the society just decided to scrap pay parity with the central government pay commission scales for its own employees. Naturally, the employees challenged this move. But get this, initially the Delhi High Court actually ruled against them. The High Court's logic, they basically said that because AFGIS was a self-financed, self-governed body that wasn't getting a direct budget from the Consolidated Fund of India, it simply wasn't legally the state. But when this got to the Supreme Court, they immediately spotted a massive contradiction. They invoked this legal doctrine called approbation and reprobation, which is essentially just a fancy lawyer way of saying you can't have your cake and eat it too. See, AFGIS was perfectly happy playing the "we're the government" card whenever it was time to ask the taxman for exemptions. But the absolute second their own employees demanded fair pay, all of a sudden they claimed to be a completely private club. The court basically put its foot down and made it crystal clear, you absolutely cannot play both sides of the constitutional fence like that. So to actually correct the lower court's ruling, the Supreme Court had to look back at this firmly established trilogy of precedents. You've got the Ramana Dayaram Shetty case in 1979, Ajay Hazia in 1981, and Pradeep Kumar Biswas in 2002. And they really needed to revisit these because, honestly, over the years, there had been this slow legal drift. Right around the 1990s, courts had started leaning way too heavily on a financial dependency test. This 2026 Ravi Kokar case, it was essentially the Supreme Court slamming the brakes on that drift and dragging the focus right back to the original intent of those older rulings. Which brings us to Section 3, Beyond Finance, the cumulative test. So, completely reversing the High Court, the Supreme Court made a totally definitive ruling, explicitly stating, financial dependency is not the only criterion. They clarified that just because an entity manages to pay its own bills and is self-financed, that does not automatically turn it into some private, unaccountable club. Look, money is a factor. Sure, we all know that. But the mere absence of direct government funding, that is absolutely not a get-out-of-jail-free card when it comes to dodging constitutional obligations. Instead of just staring at the bank accounts, the court reaffirmed what we call the cumulative test for Article 12. It's really not about any one single factor. It's about stepping back and looking at the entire picture of government domination. When they looked closely at AFGIS, they found incredibly deep administrative control. I mean, for instance, the Board of Trustees was made up entirely of serving Indian Air Force officers. Plus, their establishment and deputation rules actually required the president's sanction. Add to that, membership was totally compulsory, mandated by government instruction, and they were clearly performing a core public sovereign duty, which is the welfare of armed forces personnel. Ultimately, the court ruled that this level of deep administrative control, combined with a sovereign duty, is independently sufficient to make an entity the state. It doesn't even matter where the money comes from. Moving on to Section 4, the cooperative contrast. Not all are state. Now, right around the same time in April 2026, the court ended up deciding another really pivotal case. This one was Ram Chandra Chowdhury versus Roop Nagar Dugd Utpadak Sahakari Samiliti Limited. But unlike the Military Insurance Society we just talked about, this specific case involved a milk producers cooperative society. And this just brilliantly illustrates the contrast here. Think about it like this. On one hand, you've got Aphis Gages, deeply embedded and controlled by the state apparatus, run by serving officers, requiring presidential sanction, with mandated membership, all while performing a core sovereign duty for the military. It is, without a doubt, the state. On the flip side, you have this milk producers cooperative, which operates entirely independently. It just doesn't have that deep, permeating government control or any kind of sovereign function. So the court ruled that independent cooperative societies like this one are most definitely not state under Article 12. So what you really need to take away from this cooperative ruling is that because the milk cooperative is independent, you simply cannot treat it like a government body. If there is an internal election or some governance dispute, those issues have to go through the self-contained statutory mechanisms of the relevant Cooperative Societies Act. You can't just bypass all that and throw down a constitutional writ petition under Article 226. Furthermore, the court actually used this judgment to clarify a really important point. The right to vote and the right to contest internal elections within these societies, those are statutory rights. They are not fundamental constitutional rights.
And that leads us nicely into Section 5, Doctrinal Shift. Why it matters.
Look, the Ravi Kochhar judgment represents what is arguably the most significant doctrinal refinement of Article 12 we've seen in the last year. First off, it aggressively pushes back against this huge over-reliance on financial dependency as the ultimate litmus test. Secondly, it really re-emphasizes that heavy administrative control is completely enough on its own. And third, it strongly prioritizes the actual nature of the duty. Meaning, if you're performing a core public or sovereign function under government instruction, you are accountable, period. This whole shift ensures that government entities literally cannot just hide behind a convenient shield of self-funding to escape constitutional accountability to their employees or the general public. So as we wrap up this explainer, I want to leave you with a really vital question to chew on. As the government continues to innovate, constantly spinning off its duties into these self-funded, seemingly autonomous private bodies, who are you going to hold accountable when things inevitably go wrong? The 2026 Supreme Court rulings give us a totally powerful new lens for this. Follow the control, follow the function, and whatever you do, don't just follow the money. Keep questioning the structures around you, and as always, thanks so much for joining me.